how much can you really get from a car accident settlement? Hey there everyone, my name is Peter Geraci, the Slam Dunk Attorney, and my goal is to make sure that everyone with a car accident case makes it a slam dunk. Today, we're going to be getting into how car accident cases are actually valued. We'll be going through all the different factors so you can see exactly what influences the amount you're going to get at the end of your case. And so the goal is to make this as simple as possible. We'll try and break it down as simply as possible to show you all the factors that are typically considered when determining a settlement amount. And just a quick disclaimer, your mileage may vary depending on your state, your facts and case circumstances, so just keep that in mind as we go through this. First things first, what is a car accident settlement? Well, a car accident settlement, it's a financial agreement between two parties. Typically it's between you and an insurance company where you agree to waive your claims or resolve your claims against the insurance company and the person that caused the wreck in exchange for a certain amount. Now, typically what this means is you're not going to end up in a courthouse if your case is settled. It's entirely possible you can settle your case at the courthouse, but you might not necessarily get to a trial. Now, these car accident settlements cover a variety of damages from medical bills to lost wages, but again, every case is unique and each state has a different set of laws depending on what each settlement encompasses. For instance, here in Georgia, we have different settlements for property damage and for bodily injury. Those are separated into two different categories. Let's say 2 or 3 years in the future, something else happens as a result of the injuries you sustained. Well, you're not going to be able to do anything. You're kind of out of luck because the moment you sign that release and that settlement agreement, you're done. There's no coming back later on. So you need to make sure that that settlement amount encompasses all the damage you anticipate occurring due to the injury sustained as a result of the wreck. Alrighty, now that we've gotten that out of the way, we want to go ahead and jump into the factors that influence your settlement amounts. Now, like I said earlier, there are a number of factors that influence the value of your case, but here are some big ones that you can look out for in your cases. And some of these factors will include the severity of the wreck itself, the extent of your injuries, and the impact on your life. And that's the big one, right? How much has this injury truly impacted your life, and how long are we expecting that injury to impact your life? Additionally, the clarity of who's at fault in a case can really have an impact on the settlement amount. In situations where you might be at fault or played a partial role in the accident itself, there might be situations where your settlement amount would be decreased or even completely taken away altogether, depending on your state's laws. Most states will fall into one of three categories. You have what's called a pure contributory negligence standard, which means that if you were at fault in any sense of the word, if you were even 1% at fault for the wreck, then you don't get to recover anything in the case, right? So you got to make sure that you have played no role, have not accepted any sort of fault for the wreck, or else in a state like that, you would recover nothing for your injuries. The second one is called modified comparative negligence. And in a state like that, if you are 50% or more at fault, you recover nothing. If you're 49% or below, you do, and you recover your damages based on the percentage of fault that you're assigned, okay? So if you are assigned a percentage fault of 49%, for instance, you'd be able to recover 51% of your damages. And the final type you'll see in states is what's called a pure comparative fault. And in that sense, you can recover even if you're 99.5% at fault, you'll be able to recover for that 1% where you're not at fault in that state. There aren't many states that still follow that regime, but if you are in a state like that, then you have the highest chance and the best chance of recovering something if you're involved in a wreck where there are potential questions of liability. Alrighty, so now that we've clarified that, let's go ahead and jump back to those three factors that I mentioned earlier: the severity of the accident, the extent of your injuries, and the impact on your life. These typically what make up what's called non-economic damages in your case. These are damages that don't necessarily have an assigned monetary amount like medical bills or lost wages. We know exactly how much a medical bill is when we get it because you can see the number on the bill. But as far as the impact on your life goes, that's more of a human damage. It's an emotional pain and suffering type damage that's often determined by the jury, right? The jury's meant to assign a number, encompasses the value of the impact the wreck has had on your life. Non-economic damages are very broad. They cover a very broad spectrum from, the extent of the injury, the impact on your life, your relationships, the actual sensation of feeling pain, the mental pain and suffering, the fear of the impact, a number of things. And this pain, this impact can extend on for years and years and years on end. Typically people that are involved in car wrecks, they will be experiencing some form of pain for the rest of their lives. And it's important, very important, that you account for that when you're discussing your case with the adjuster or even the attorney that's representing you. They need to understand the full extent of the injuries and how it's impacted you. Now, most people that are involved in car wrecks suffer from some sort of non-economic damage, meaning pain, suffering, fear of driving, anything of that nature for probably the rest of their life. So it's important that you communicate the extent of the impact and the injuries that you're experiencing and their impact on your life to the attorney that's representing you. And if you're not represented, of course, to the adjuster, so they understand and they're fully aware of the extent of the injury and how it's impacting your life. Now, the reason I covered this section first is because it's the most important section here. It's the most important factor as far as how settlement amounts are influenced. If these damages are properly documented, you communicate them to your medical providers and they know it's documented there, you're suffering and you're continuing to suffer. And what helps even more is if you have people in your life, friends, co-workers, family members, churchgoers, neighbors, anybody that can really speak to how this has truly impacted you, you'll see the value of your case jump through the roof. Now, like I said at the beginning of this video, your mileage may vary. Again, it depends. It really depends on how convincing and how solid your evidence is of your non-economic damages. While it may be the most valuable part of your case, it's also the most difficult to prove. Most adjusters are very skeptical of non-economic damages because people often fluff up the impact of the wreck on their lives. And so that's why it's important to have others who can testify to the impact it's had on your life. And just to give you all some examples of what you might consider as far as having an impact on your life, most people that we'll see after a car wreck, they'll have trouble, let's say, taking out the trash, mowing the lawn, maybe bending down to pick up things, helping their significant other with tasks around the house, enjoying activities with their kids, maybe going to the beach, sports, things of that nature, things that they do on a daily basis without really thinking about. But now that they have this pain, they kind of have to think twice before they engage in that sort of activity. That's the sort of pain and suffering we're talking about, at least in most cases. For some more severe cases, you're going to be dealing with a whole other level where you're not able to walk anymore. Maybe you lost your hearing, maybe you've lost an arm, whatever it might be. Of course, the pain and suffering in those cases is a lot more severe. But that doesn't necessarily mean that non-economic damages should not be considered in your more minor cases. All right, let's go ahead and jump into the next factor, which is going to be lost wages and loss of earning capacity. Now, most minor cases aren't going to keep you from working for very long, but if you are in a situation where you're forced to change jobs, or let's say you can't do a more serious job or you lost promotional prospects due to the injuries from your wreck, this can be a huge factor in the value of your case. Now, typically what you need to prove up this case is an expert, an economist, to prove up exactly how much you stand to lose in the future due to your loss of earning capacity, okay? So they have to be able to calculate based on the job that you would have had or you would have been able to do, how much money you would have made had this injury not occurred. The second expert, or rather the testimony that you would need, is from a medical doctor stating that you cannot do the job that you're saying you can't do. We have to be able to support the contentions that we're making in the case, because otherwise it's just anybody can go up and say, oh yeah, I can't do this job or I can't work. There has to be some sort of actual evidence or support for the contentions that you're making. Now, a tip here is to make sure that you are documenting each and every day that you are missing from work. Note all the times you're experiencing difficulty with your work. Make sure you inform your doctors what you're experiencing so they can note it down in the records. That way it's documented. There's never any question about when you started complaining about this and when it became a problem. And that pretty much covers it for lost wages and loss of earning capacity. It's a relatively simple claim if you have the proper documentation and the experts in line to support the contentions that you're making. Now let's go ahead and jump into the next one, which is probably my least favorite, and that's medical bills. Now, medical bills are pretty straightforward, right? It's the amount is there, and that's what should be paid in under most circumstances. What happens is when you submit your medical bills to the insurance companies, most often what they'll do is they'll question the amounts and how the doctors and billing team came up with the amounts that they're billing for. And so they'll attack the bill. They'll say, oh, they charge you too much for this, that, and the other, but then they don't really do anything. You're the one that has to go and negotiate that yourself. But under most circumstances, you will get paid the value of your medical bills and should be made whole through that. The only thing that I would suggest here, and the best way to keep track of this, again, is get a folder and keep track of all the medical bills you receive as a result of the treatment you underwent for the injury sustained in the wreck. Now, just because they're my least favorite part of the case doesn't mean that adjusters don't like them. Adjusters use medical bills to make up a bulk of the value of their case. They'll rely pretty heavily, actually, on the value of the medical bills in determining the severity of your case. Typically, it's assumed that if you have higher medical bills, then your case is a little bit more serious. Now, of course, there are certain circumstances where that's true when we're talking about broken bones, fractures, things of that nature. Now, while there may appear to be a correlation between the severity of a case and the medical bills, it's not necessarily determinative, right? Just because your medical bills are low, it doesn't necessarily mean you have a minor case. You could have no medical bills and have a broken foot. Just because you didn't go to the doctor doesn't mean that you didn't sustain a severe injury. But keep in mind, that's what adjusters are thinking, and that's how insurance companies are thinking. If you don't have high medical bills, your case probably isn't that serious to them. Alright, so now that we've covered a few factors, let's go ahead and talk about insurance and policy limits. Now, I hate to say it, but policy limits play a pretty big factor in case values and settlement amounts because they limit, typically, the amount that you're able to recover in a given case. Now, most cases, in my opinion, will probably exceed the policy limits that are available under most circumstances. On average, most people are driving around with the bare minimum coverage in their state because that's all that's required to drive, and most people don't know that they need more than that's actually on their vehicle. So it's important to be aware of what the policy limits are in your case so that, let's say you need more treatment or further treatment, you'd have to find probably another way to get that treatment done at a cheaper cost, or maybe possibly through your health insurance. That way you're not running into an issue later on when you have minimum policy limits that you're dealing with. A number of states have different policy limits that they work with. For instance, here in Georgia, the minimum you need on your car is $25,000 per person, $50,000 per accident, and $25,000 for property damage. There are some states that only require $10,000. $15,000, right? So you need to be aware of what's on the other side, what they have available, so that you can work with that as you progress through your case. Now, a number of states have ways to get around these listed policy limits, which is amazing, but they're only available in very limited circumstances. The way you would go about settling your case for above the policy limits depends on your state's laws. For the sake of this video, we'll talk about Georgia because that's what I'm familiar with. Here in Georgia, to get around the listed policy limits in a case, we first have to give the at-fault driver's insurance company an opportunity to settle the case within the listed policy limits. We have to show them that the case is worth in excess of the policy limits. If and when they decide that the case is not worth the policy limits, or they decide to offer something less than the policy limits, we then have the opportunity to take them to court and potentially argue that they have acted in bad faith by failing to settle the case and protect their insured from an excess judgment above their policy limits. Now, what that means is that if we go to court, for instance, and get a verdict from a jury that's above the listed policy limits, typically the person that was at fault is actually responsible for paying that. But the person that's at fault then might have a case against the insurance company for the amount in excess of the listed insurance because they, the insurance company, should have settled the case for less when they had the opportunity to do so and should have protected the interests of their insured. Now, typically what happens under those circumstances is the injured party, in exchange for the rights to pursue that case directly against the insurance company, they'll waive collecting the judgment in excess of the policy limits against the actual insured driver, if that makes sense. So that's really how you get around the listed policy limits. It can be very complicated. I would not suggest you do this on your own, but it's something, and it's a way to get around those listed policy limits in cases where the case value exceeds the actual listed policy limits. Now, to avoid this issue altogether with low policy limits, what I would suggest is making sure that you have high uninsured motorist coverage or underinsured motorist coverage on your policy to protect yourself. That's what they're there for. I would also suggest adding medical payments coverage to your policy just for even more coverage in the event something happens. Now, when you have all that together, let's say you're at the end of your treatment, You've got all these factors together. You have all your supporting information. Typically what you're going to do is put that together in a demand letter, and you're going to send that off to your insurance company, or your attorney will do that for you. Now, depending on how persuasive your demand letter is and the information it contains, that will again vary the settlement amount you're going to get at the end of the day. Typically what we like to include in our demand letters are similar verdicts or similar settlements in cases that are close to or nearly identical to the case that we're working on. That way there's a baseline or a foundation for the amount that we're asking for. The job here is to make it as easy as possible for the adjuster to do their job and pay the amount that we're requesting. All right, and the final thing that I wanted to discuss is attorney involvement. Now, I know everybody wants to, handle their own case and get as much money as possible and save as much money as possible. Really, it does not make sense in most circumstances for you to handle your own case. There are a number of studies out there that highlight the benefit of having an attorney in your case. For instance, the Insurance Research Council conducted a study back in 1999 on this exact subject. They wanted to understand how much an attorney's involvement played a role in the value of a case. Well, what they found was a 350% difference when an attorney was involved in a case. That's huge. That's a significant amount, and that's over a number of different cases. Now, this doesn't mean just go hire any attorney you see on the road. You still have to do your research. But for the most part, an attorney's involvement is going to net you more money. You don't have to do the work. You don't have to do anything. You just give them the case and let them do their work with it. This is not one of those situations where you try and save money or do it on your own, because there's so many pitfalls and places where you can mess up that can really damage the value of your case. Now, to wrap up, the amount you can get, again, really depends on your case, your state, and a number of factors like we discussed. But ensuring you have support for the contentions that you're making in your case is crucial. Documentation is crucial. And having good support for the non-economic damages in your case can be huge, a huge boost to the value of your case. Alright, everyone, that about covers it. I hope that was helpful. If anybody has any questions about their particular facts or circumstances, leave them down below in the comments or send me a DM. I'll be happy to answer any comments or questions that y'all might have. If y'all like this video, please leave a like, subscribe to the video for more, and let me know what else y'all want to see. I'm here for y'all. Alright, y'all, we'll see you in the next one.